Privileged to extend a warm welcome to you all at the National Seminar on 1 Year of India's New Criminal Laws, organized by DME Legal Aid Cell in collaboration with the District Legal Service Authority, Gautam Buddhanagar, and media partner Law Bhumi, Knowledge Teas, and Law Octopus, hospitality partner Jai Viru. We are truly privileged to have amongst us today distinguished legal luminaries and esteemed guests. We welcome Dr. Tia Nawal Sir, former District and Session Judge, Delhi, former Chairperson of DLSA, Shadra, Delhi. We also welcome Professor Dr. Upma Gautam Ma'am, Faculty of Law, USLLS, Guru Gobind Singh in the Prastha University, Delhi. We also welcome Dr. Abhimanyu Chopra Sir, Advocate, Partner, AZB and Partners. Abhimanyu Sir will be joining us shortly. To commence this glorious event, I would like to call up our moderator for the event today, Ms. Amrapali Sharma Ma'am, Assistant Professor, DME Law School.
Good afternoon, everyone. Good afternoon, our esteemed panelists and the audience members and the faculty members present here. I am Amrapali Sharma. I am an assistant professor at DME Law School, and I have been given this honor and privilege to moderate today's session on 1 year of India's new criminal laws, strengthening legal aid for equitable justice. Now, I want to narrate a success story or an anecdote to you. So, in April 25, 2025, in Mangolpuri, Delhi, a deeply disturbing case surfaced whereby a 16-year-old girl gave birth at a government hospital, revealing repeated sexual assault. Now, there was a prompt PCR response, which led to registration of FIR under BNS 2023, along with POXO Act Section 6. After that, the investigating officer displayed swift investigation, and the testimony of the victim was taken following child protection protocols. The DNA profiling was also done, which led to conclusive evidence that there was a relationship between the accused and the child that was born. So it established the father-son relationship between the child that was born to the 16-year-old as well as the accused. Now, the entire forensic investigation was done, the corroboration was done within a record time of 31 days. And the charge sheet was filed within a record time of 31 days. Now, this was followed by fast-track court proceedings, which framed charges on 28th March 2025, and the hearing was started. Now, the hearing happened in record time of 18 days, and the accused was convicted of all the offenses and charges, and within 49 days of filing of FIR, the accused was sentenced to rigorous life imprisonment till the remainder of his natural life. So this was the first case in BNS, under BNS 2023 and POXO Act in Delhi, which led to life imprisonment case. And the conclusion of case was done within 49 days. This leads us to believe that the new criminal amendments that have taken place, they have They follow a victim-centric approach. They are also time-bound, and they lead to a scientific policing approach. And if followed correctly, we can have expedient justice as was demanded when these amendments were made. So this was one of the many success stories that have been documented within this last year of criminal amendments which have taken place. And today we are here to discuss the performance of these new criminal laws in the previous year, because 1st July 2024 marks the watershed moment in Indian history, Indian judicial system, where by the three prominent criminal legislations were completely overhauled, and they were made completely overhauled by new legislations, and they were replaced by new legislations. Now, these new legislations were BNS, which is Bharatiya Nyaya Sanhita, which is the substantive law, and it replaced the Indian Penal Code of 1860. The second legislation was BNSS, which is Bharatiya Bharatiya Nyayak Suraksha Samhita, basically which basically uh, changed, or which replaced the CRPC, that is Criminal Procedure Code. And the third was Bharatiya Sakshi Adhiniyam, which replaced the Indian Evidence Act. So there were several reasons that were brought to in order to which prompted this overhaul basically. This was long due as per the Ministry of Home Affairs, and there were several key reasons also that were given for this paradigm shift in our criminal laws. First reason was that we had to shift from this colonial era mentality. So the IPC, CRPC, and Evidence Act, they were brought by Britishers, Lord Macaulay to be very specific. And the main idea behind these laws was that they had to enforce paramountcy of British rule amongst Indians, or the people that they were ruling. So in order to ensure paramountcy of British rules, these laws were based on oppression, ruling, and punishment, instead of being a justice-based approach. So the new criminal amendments, or the new criminal laws, they follow a more justice-based approach. Secondly, there has been a changing nature of criminal activity, such as inclusion of cyber crimes. So with the advent of technology, we have different crimes, or different cyber crimes that are now happening, which did not find any place in the previous laws. Even though we had we had several amendments to include those crimes or the advent of technology, it was still inadequate. So inclusion of technology was a very prominent change maker when it came to introduction of the new laws. Thirdly, older laws were outdated, rigid, and non-reflective of the contemporary mindset. So as I've already told you, they came with a colonial mindset of their own, and that is why they were rigid and outdated. Now, the last reason for it was to incorporate modernization. So we have specific provisions, especially in BNS, which talk about certain modern concepts like community service as a punishment. So community service is something which is done in foreign jurisdictions, but was not applied here in India. And that is why this has been made applicable, or it has been introduced as an experimental form of punishment in Indian jurisdiction as well. So with these, we have an idea of what was the reason behind these laws, or what was the objective of the ministry or the government of India behind introducing these laws. Now, coming back to our today's session, we'll be starting with the panel discussion, and I'll be introducing our esteemed panelists that are sitting here. So first of all, I would like to welcome Dr. T.R. Naval, Honorable Justice Dr. T.R. Naval. Please. So Dr. T.R. Naval has an enriching experience of more than 31 years. He has been a former district and sessions judge of Karkarduma District Court, Delhi. He has also worked as principal judge at Family Court, Delhi. He has also worked as additional district and additional sessions judge, along with being a special judge in different trial cases pertaining to POCSO as well as SEST Act. He has also been a chairperson of Shahadara District Legal Services Authority, along with being a prominent author. And right now, he's a founder of Naval Associates. Welcome, sir. We look forward to have your enriching experience that you can share with us on the new criminal laws. Thank you. Now, our second panelist for today is Professor Dr. Upma Gautam. Ma'am has had an illustrious career as an academician, and as an academician myself, it seems to be one of the most motivating profiles that I can look up to. So ma'am has been a senior faculty member at University School of Legal Studies. She has had more than 19 years of experience, and her specialization lies in criminal law, CRPC, criminology, constitutional law, cyber law, women in law, etc. She has also been recipient of major awards, one of them being selected for 8th Venus International Women Awards 2023 in the category of Outstanding Women Researcher in Law. She has also received Research Excellence Award 2022 for her paper on attainment of sustainable development goals of empowerment of women through active employment. Apart from this, she has also received the award for Best Paper in the ICSSR Impress sponsored conference on her paper titled Spatial Dimensions of Understanding Nature as a Person of Law. Apart from this, she has also been a part of major research projects, four of which were under the faculty research grant scheme of IP University, Delhi, and one was under Department of Law and Justice, Government of India. Now, additionally, 3 of the projects are undergoing, and they are undergoing under the Government of India, namely under ICSSR, National Commission of Women, and Ministry of Law and Justice. Apart from this, she has attended several conferences, more than 12 to be specific, and it includes both national and international conferences. And she has to her kitty publications in various chapters and various books and various journals as well. Ma'am, we welcome you wholeheartedly to the panel, and we look forward to gaining from your experience. Now, we have been joined by Dr. Abhimanyu Chopra as well. Thank you, sir, for joining our panel, esteemed panel. Dr. Abhimanyu Chopra is a partner at AZB and Partners law firm, and he has had an illustrious career. His specialization lies in white-collar crimes, and he has been part of many special projects and organizations, and has good publications under his hat also. Last but not the least, we have Professor Dr. Komal Vij, ma'am, with us. Ma'am is the Additional Director of Delhi Metropolitan Education. And apart from it, ma'am has done her LLD in criminal law and MBA in HR, and she has served in different capacities for more than 20 years. Now, to her kitty, she has published more than 95 research papers in international and national journals, including 23 scopus, 12 books, and 30 plus book chapters, 50 plus conference papers and publications, and she has supervised 6 scholars who have successfully completed PhD under her guidance, and many others are pursuing. Her area of interest is criminal law, family law, and laws related to women's rights. Ma'am, we welcome you wholeheartedly to the panel. Before moving forward, I would just like to acknowledge and for you all to acknowledge what a diverse panel we have amongst us from different walks of life. We have academicians amongst us. We also have former justice amongst us. And we have on the other side of the bench, Dr. Abhimanyu Chopra, who will guide us with his advocacy skills and what all have advocates faced when it comes to the changes in the new criminal laws. So please, a huge round of applause for such a diverse panel. All right, so now we'll be starting with the panel discussion. Before starting with that, I would just like to apprise you all of the themes and the sub-themes that are present here, that are a part of the conference. And so it is basically divided into three sub-themes. Sub-theme one talks about procedural reforms under BNSS, which explores timelines for investigation and trial, mandatory audio-video recording, provisions for custody, etc. Sub-theme 2 talks about victim-centric provisions in new laws. That means provisions related to victim compensation, provisions related to Witness Protection Act, as well as the provision of legal aid to the indignant persons who cannot afford legal aid themselves. And lastly, sub-theme 3 talks about safeguarding rights of the accused and underprivileged under BNSS. So BNSS talks about the various rights of under trial prisoners and the accused and the marginalized communities that uh, could take help of legal aid provisions under the new criminal laws. So starting with the panel discussion. Yes.
Before starting the panel discussion, we would like to welcome the guests with a Tulsi sapling.
A true welcome is never complete without warm words and warmer gestures. It is an honor to have you as the guest today. I now request Officiating Director, Professor Dr. Komal Wig ma'am, to please felicitate Dr. T.R. Raval sir. I also request Professor Dr. R.K. Randhawa ma'am, HOD DME Law School, to present a plant to Professor Dr. Upma Gautam ma'am. I request Professor Dr. Neha Behel ma'am, convener DME Legal Aid Cell, to present sir with the planter, Dr. Abhimanyu Chopra sir. Thank you.
Yes, starting with our first question for panel discussion. Dr. T.S. Naval sir, the question is directed at you. So recently in the Rajya Sabha session in February 2025, the Ministry of State of the Minister of State for Ministry of Law and Justice, Mr. Arjun Ram Meghwal, was asked to state dependency of cases in judiciary. So according to his answer, in Supreme Court, we have around 81,000 cases that are pendent as of today. In high courts, we have 62 lakh cases that are pending as of today. And in all the district and subordinate courts, we have more than 4 crore 50 lakh thousand cases pending as of today. Now, this BNSS allows for stricter timelines, as we have already seen in the success story that I also told in the starting of the discussion. With introduction of these stricter timelines in the new BNSS, how do you think the justice delivery will be expedited? We would like to know your opinion on it, sir.
Namaskar to all of you. I am very glad to talk with you. And in this regard, first of all, I want to talk and I want to say that I speak very less. Whenever I speak to the point. And that was the reason that when I used to write my answers for LLB or LLM, I never wrote 3.5 page for one answer. So I am very miser in speaking and writing too. My straight answer is that for the next 3 years, nothing is going to be changed. Instead, conversely, that will burden the system. And after 3 years onward, that positive result will come. And there are so many enactments in which it has been mentioned that particular case has to be decided within 3 months. But when a case is filed before the judge, on the first date, judge give date after 3 months. First day is given after 3 months. So it is practically impossible to decide the case within timeline. Although BNSS has provided timeline, but it is very difficult to achieve the timeline. It is not possible by the police and it is not possible for the judiciary for many reasons because there are shortage of judges. Judges proportionate as per proportion outside India, the strength in judiciary is very less. So one judge has to hear around 100 cases per day. And it is humanly not possible to read all those files and to decide those files. So what happens that some cases are decided and some are adjourned. So it is BNSS presently is not going to give good result in 2-3 years.
Thank you so much, sir. Just a follow-up question with regards to that. So, while doing my research, I came across a judgment which was basically regarding establishment of different benches of Supreme Court in different parts of the country. So the Constitution has this provision that the Supreme Court can work from different benches, more than one benches. However, that judgment is still pending in the Supreme Court. That case is still pending. According to you, do you think if we go through with this provision and there are different benches that are set up for the Supreme Court to hear cases, would that be helpful in expediency of justice?
My straight answer is that when I was a student of LLB and LLM, there was like me that benches of Supreme Court will be established different parts of the country. But after passing over 40 years, I have not seen even a single another bench because there are so many problems, so many challenges, and so many counter activists who do not see that benches are established in other states. So there is move, but practically I do not think that sooner or later benches will be established in India.
Thank you so much, sir. Dr. Upma ma'am, yes, if you can applaud if you want to. That's okay. Upma ma'am, same question to you. Do you think that inclusion of stricter timelines in BNSS, for example, that the new law says that a rape victim has to get her medical testing done within 7 days of registering the complaint, and there are many such other provisions also. So do you think that introducing stricter timelines would help in expediency of justice?
Thank you for the same question, though my answer would be very different. Not that I disagree with him. First of all, I really thank that I am being invited and I am being having an opportunity to interact with you all. See, first of all, new criminal laws. As an academician, if I see, as a criminal law student, if I see, it has made my life miserable for the very simple reason that had I known any other law, because I'm teaching criminal law for last more than 20 years, and had I have the capacity to teach any other law, I would have shifted, because learning new sections at this age, learning new this thing. But what made my life easier is that everything still more or less remains the same. Okay, the judgments, the concepts that are applied, okay, there are changes, I'm not saying. Now if I compare BSA, BNS and BNSS is majorly changed, approximately 30% if we are very positive about or very optimistic about. And if I compare BNS, it is hardly 10%, and if BSA, hardly 2%. So the thing is that what all has been changed, it will take another 3 to 4 hours discussion, and it is not something that the time will permit us, because again, so the thing is, the question is pendency, how expedient the law would be, the law application would be. See, mm, it will not matter. In letter it is changed, in letter it has been changed, no doubt about it. The timelines have been there in civil procedure law also, as far as when there was, it was a huge what to say, a talk of the town, that okay, now there would be timelines, the number of adjournments would be there, they are fixed, like. But then and now also timelines are being fixed. Now the question is, as sir, complementing to what sir said, because he was there in the system, he knows the system better than what I do. Because you know what, is it possible to follow the timeline? First of all, we are not a bureaucratic criminal justice system, number one. Bureaucratic criminal justice system talks about timelines, it talks about the targets. Okay, we are not a corporate this thing that okay, at the end of the month, in the 30th, we have to finish this much of business. Okay, so now we are not following a bureaucratic criminal justice system, though the performance, because we are talking about performance, the question is, what would be the guidelines of performance? How will we measure? What are the scales that we are talking about? How do we measure performance? Is it the output, as in number of cases that are disposed of, or is it that how well we have disposing of the cases? Now the limitation of the judges nowadays, because I'm having many students on the bench and the other side of the bench, thankfully. So now the thing is that, you know, the judicial officer has to see many things at a point of time. It's not only that okay, like a machine, he has to follow the timeline, that okay, there are too many stakeholders involved in a criminal justice system. You know, as the name suggests, which we all are very proud, now it is no use of saying that whether the amendments were good or bad. Now it's no point of doing that. Now we are 1 year old, and now we are again deciding that how much things have changed, or will they change. I teach in my class, I tell my students that, see, for coming 10 to 15 years, sir only talked about 3 years. I tell my students that coming 10 to 15 years, you will be dealing with both laws, CRPC and BNSS. So your life will not be less miserable than what mine is. Okay, so why? Because again, you have to study both, you have to apply both. The judges are again struggling, because please understand, the procedural law cannot be used as a master. It has to be used as a servant, it has to be used as a facilitator, which actually just do away with the minor irregularities. For instance, I was talking to a very senior judicial officer who says that, ma'am, now till date, I am dealing the application in section 430. There are this thing where the advocates are invoking the applications, or maybe I'm listening application in this thing. It was a long back, it was few months back. Now maybe the things have changed altogether. But the question is that who is sitting on the bench, is he supposed to be so strict about the procedure? Because there is a difference between illegality and irregularity. आप अगर law भी पढ़ेंगे, if you will see the procedures, you will see as far as possible. Now, as far as possible has its importance. See, I'm not saying there is no importance of deadline. It acts on the mind of everyone. Please understand, it acts. But should it be strictly followed? Will it serve the justice more than if not followed? Because there may be many a times then when the justice requires otherwise. You know, the deadlines. As I say that we are following due process model. We are not a bureaucratic model or crime control model, though it is again an obsolete discussion of due process model and crime control model, but nonetheless it is not irrelevant. So when you are talking about due process model, what is more important? That the procedures should be given the importance of procedures only. They should not come if, and that is why there is a provision of inherent powers. There is a provision of irregular, the curing of irregular proceedings, irregularity, how the irregularities are to be cured, which irregularities can be cured, which irregularities cannot be cured. And then also, again, the judicial officer sees that, okay, if there is an irregularity, if there is this thing, then, okay, if the parties are not prejudicially impacted, if the parties are not impacted adversely, then there are certain irregularities. We all see in varied judgments. See, please understand, the one thing that I always teach my students in while teaching CRPC is, or procedural law, BNSS, is that you should more often use word generally. Generally, what, as in generally this procedure is followed. Generally, that generally changes. The word the procedure. We can't be so strict about the this thing. Any of the procedure. I'll give you one example. Sorry, I'm taking 2 minutes more. See, for instance, if I take the example of earlier section 202, now it is 223, 224, somewhere between 225 or something like that. 223 is the complaint case by the magistrate. So when you are talking about that, if the magistrate takes the cognizance in an offense which is punishable by session court, okay, so he cannot order an investigation. That is the rule. He has to go for inquiry. Now, before calling accused in that inquiry, he has to examine all the witnesses that are mentioned. Now, the cases, the word written there is shall. He shall examine. But is it shall? If he doesn't, suppose if the magistrate comes to the conclusion after examining 5 witnesses that, okay, I have to call the accused, then what? So again, that particular prerogative of doing the justice was always there in procedural law, is required also. So affirming by what sir said, that yes, it is good to have deadlines, but how far they would be just, how far it would be just to follow those deadlines in every circumstance, yes, that is a matter of question. That is a matter which is to be seen in every particular case. You know, the argument changes when you are at that side of the table and this side of the table. I always say that speedy justice is the proper justice that is not required. What are we achieving? Is achieving, for instance, I'll give you another example. In Gurgaon, when the killing happened in the school, the first, if the children here remember, or the teachers who are sitting, or my fellow colleagues are remembering that, you know, the ultimate thing that was cropping up immediately after, because nowadays we are living in media trial and everything, the thing that cropped up was that the conductor did the rape, there was sexual assault, the conductor was involved, this was involved, that. But what happened at the end of the day? That there was a school child involved in that murder who did that killing just to have the exam postponed. So please understand, instant justice, the very speedy justice, the shifting to the crime control model, how far we are ready to shift to the crime control model, it is something that we need to what to say, yes, deliberate upon. And is it required? Is it required every time that the judge should follow a timeline? He might be this thing. So again, please, timeline is good, I'm not against it, but again, more important is that how effectively we are. delivering the justice. And that requires a whole new session altogether, that what are the ifs and buts involved in the procedure. So that is what this.
I want to add that a result of PNSS or all other law depend on the person who implements those law. If the man who implements the law is dedicated, sincere, honest, efficient, then result will be very good, excellent. And if the person who is supposed to implement the law is inefficient, biased, prejudiced, dishonest, then it will not going to give good result. So it depends on the character, honesty, sincerity, efficiency of the persons, stakeholders, legal system functionaries who will who will make the system either excellent or bad.
And a few this thing, timeline is not always good also. For instance, you have set the timeline of framing the charges. I'm not criticizing, please understand, the coin, there are two sides of the coin and coin itself, okay? So when you are facing the timeline for framing the charges, that means the judges are criticizing it, that means we have to wait for this much of time, the discharge application. So there are very this thing wherein the people have made it with all good intentions, but I'm not denying that, but whether they actually will serve the purpose, 1 year is too less a time to see that.
Yes, ma'am. Thank you so much, ma'am, for explaining it so meticulously. Sir, same question to you for being part of the bar. We would like to have your opinions on the same.
Thank you so much. Thank you for having me. I'm presuming everybody is a first, second year student. So I'll try and maybe go a little more macro than what micro went. And effectively, please understand, we have the theory, we have the judiciary. I am now basically the user. To simply put, how many of you started with the law school intention after watching a foreign TV show? Okay, you're in for a surprise, is nothing like it. In India, our legal system, at least the criminal justice system, is an adversarial based thing. And when you do these matters, you will realize that what everybody is pointing out, it depends from which side you're appearing for. So if you are the prosecuting agency or you are the victim, you will obviously want things to be done in a speedier manner, in a faster manner. You want things to be done on a drop of a hat. There should be instant investigation, there should be instant conviction, and there should be instant prosecution. When you are a person who's defending, you're always on that back foot because you're fighting against two people. One is the victim's lawyer, one is the prosecutor's lawyer. And when you are fighting against two people, you will always want to win. And when you are fighting against two people, you will always want to win. Now, what are the charges? What are the charges? You know, when there are subsequent amendments, you want to wait for application. So there are various stages. I think I'm enough to talk only these things, but again, I'll keep it short. But when you're doing it for the side that you're investing, you have a lot of factors to look into. Let's say there is an accident. You're actually going on the road, you're in a car, and you hit another person. See, it wasn't meant that way. Yourself against the cost of the damage. That is the civil side of it. But now if somebody gets hurt, oh, you're in for a surprise. The kind of problems, the kind of the process, and then it is going to be so long, and at the end of it, you realize, oh, I made such a big mistake. That's why people have started keeping Ola Ubers. They don't drive when they're drunk. And now let's look at this one event. If you hit somebody, first you'll be arrested, taken to the police station. Arrested in the sense you'll not be handcuffed, but you'll be taken to the police station. You will have an MLC to see whether you were drunk, whether you were intoxicated, were you inebriated, whether you were high on some substance. While this is happening, there is going to be a parallel bail proceeding going on either with the SHO or with the court if the SHO is disregarding because there is a pressure, there is a high stake involved. Now, this one hit has taken your entire day. Now, imagine this happens on a Thursday. You go to the bail court maybe on a Friday, but if it's happening on a Saturday, you're stuck in the jail cell for that 2 days. There is no streamlined way out of it. But then you get bail, then you come out. Now the police will investigate how the car was functioning. The car will go into the garage. There will be a checkup. There will be an investigation whether the brake was working or not. And please remember, India is a cheap litigious country. Nobody will go for plea bargaining until this is a heinous offense or they are looking really outrightly that they'll get a benefit of that doubt. So you will contest this matter that I did not do it. In the meantime, you're also looking at the victim, whether the victim has got an adequate hospitalization, adequate amount of money for the purpose of settlement. So parallelly, three things are going on. So when you're looking at these events, it is not as simple as a black and white thing. Now coming to the timelines, your timelines will always depend from the side you're representing. If you are the victim, you would like instant. If you are a person who's defending, you would say, let it go, we'll take adjournments, there'll be investigation going on, there'll be forensics going on, the MLC report will come, and they come from various places, sometimes centralized, and depending upon the state you are in, that kind of matters. So from a macro perspective, the act which has now come in provides indicative timelines for doing certain things. Whether that happens, maybe. But when you have a simple thing as a 138 case, you have special statute like the SCST Act, it can never happen because your first two dates will be just completion of pleadings and somebody will take an adjournment. The adjournment system in India is sometimes counterproductive, but sometimes it's strategic. In the law firm nature, we call some adjournments to be strategic adjournments, where we know that if there is a particular, so sorry for that, but if there's a particular judge who may be more harsh, or there's a particular judge who's about to come and who will be more lenient, because we are all human. We all consider certain events in a specific manner. I may have a thinking of something to be fine, something to be illegal. That perception also changes because there's not strictly law. And the discretion in these things matter. So if the judge agrees to an adjournment, you may have more time for defense. But in case they don't, then you have to prepare yourself accordingly. So as lawyers, the only thing I request maybe when you start coming into these procedural laws, you understand how you're going to deal with it. Some things are common to everything. The process will be same. Timelines will be same. But when you come into practice, it's completely at variance because you will defend your client to the fullest capacity and to your fullest commitment for the side you're working on. You will not say that, okay, my client may be guilty, but let's speed track the entire issue. You have to defend your client. As an officer of the court, you cannot lie. But as the best possible alternative and defense to your client, you will work in whatever parameters you're working with. And when coming of special laws, where there are stricter timelines, like the SCST Act does not talk about anticipatory bail. So imagine a situation where you have just having a conversation with a friend and there is a caster's remark. Now under CRPC, there could be a complaint under 200, there could be an action otherwise, the FIR may not come in. But the moment there's a caster's undertone remark and there's a special statute involved, FIR will be instant. And then you will be fighting yourself in a special statute before a specially designated court under a specialized law. The procedure still remains the same, but the action starting the investigation has completely changed. So these are parameters you will get into, and when you come to the practical side of it, you will realize, oh, we are in for a nightmare. It's not easy. Thank you.
Thank you, sir.
Strategic adjournment, what Abhimanyu was talking about. See, there was mine case only, check bouncing 138. And the first, and it was though not a very big amount. Again, how grave the injury is depends. Okay, the check amount was 10 lakh. And that was not a big amount, so-called, to be instant, to act so speedily. But for me, who is a teacher, who is a this thing, 10 lakh amount matters. I was supposed to have many things lined up and I was needing that money. But the first date I got was of approximately 8 to 9 months. And that was early because when I was teaching in Haryana to the prosecutors and I was telling them that some procedural law only, he said, ma'am, it is very early. In Haryana, if you will see, it will be more than 1 year. So you got early 6 months. Yes, 6 months. It was 6 months. So please, now strategic, why? Because judges were seeing, why? Because this entire thing is that maybe the parties will compromise. Maybe the money will be returned in between. So there is a strategic in dating, the giving of date in particular matters. which are beyond what is written in law.
How is the case still over?
Yes.
That is a nuanced thing.
Yes, and with the involvement of police, because otherwise it wouldn't have been.
So a settlement.
And yes, no, and because for that also I required my students only.
One more thing I wanted to address with regards to the circuit benches of the Supreme Court. This is a very, I would say, a very controversial topic according to me, not relevant to this. However, since Sir pointed out, I'll just add on to this. In India, if you start having circuit benches of the appellate court and the superior courts, I will tell you what people will start doing. People will start trying to game the system. And how simple is that? You will change your registered office address. Once you have changed your registered office address, you will have a circuit bench in the south. They will try and take that matter there. Because why? They believe they will be more powerful there. That is why the strategies of circuit benches do not work. When you have something similar as the NCLAT, who has now a Chennai bench, you clearly see the disposal rates. Why you have 5 benches in Delhi, you have 2 benches in Chennai. The disposal rate are so much variance because people will try to again take adjournments. They will argue, and lawyers love to talk because we get paid. We like to draft because we get money. Everything eventually works on that principle, and eventually those circuit benches lose the entire benefit. The only principle of circuit benches has always been that Supreme Court is too far from the south within the same country. But I believe that is the only way there will be consistency in orders, consistency in judgment, because judges at times when they are in trouble, they will get up, speak to the brother judge, which will be impossible or which should not have that way doing it over a circuit bench. And discussing judgments even in a VC based structure and in presence of people has a tendency of leaking the judgments. So that also reaches into a different kind of ambit. So I think you want to say
I want to add that sometimes genuine reasons for adjournment. If adjournment are not granted, then injustice may cause to the parties, either to accused or victim. So, in genuine cases, otherwise everything would have been handed over to computer and etc. That this is the system, these are the days, and everything will be decided by computer. So, judges are appointed because they are duty bound to consider the genuine reasons of both the parties, whether it is victim or it is offender. And it is said that a speedy justice sometimes mm, result into injustice. So everything should be decided in cool mind, properly giving full opportunity to both the parties. And if timeline is achieved or timeline is strictly followed, then injustice may be cast. This is my observation. So adjournments are unnecessary sometimes.
Timeline in filing supplementary charge sheets, that is a good thing. If done at trial, if during the trial with the permission, that is a good thing. Okay, that you have done this. But timeline of other things, as in how far they will work, time will only tell. And 1 year is. Yes.
In this matter, I want to add uh, because 60 days time and 90 days time, sentence below 10 years or up to 10 years, 60 days and beyond 90 days. Sometimes what the investigation officer do, they file incomplete investigations. So that the timeline is achieved and statutory bail is not granted. So thereafter another supplementary charge sheet is filed. Even the accused are added. So that will also result into delay or prejudice is caused to the earlier accused who were apprehended or faced trial. So this is one of the reason. And in genuine cases, filing of supplementary charge sheet is necessary because there may be genuine causes where new evidence might have revealed, you might have find the new evidence or new things that should be brought into the judicial record. But sometimes it is seen that strategies are adopted to bypass the laws and create circumstances even for the trouble of the judge, and that caused prejudice and injustice to both the parties.
And that is why the discretion is with the judge, that if that timeline is to be extended, it can be with the permission. So timeline is there, but the discretion of the judicial officer is also there.
Thank you so much, panelists. Thank you, Dr. Chopra, for your insights. To the audience sitting here, I would like to tell you that AZB and partners have started a series of articles on their website about Know Your Law, India's new criminal laws, transition from ruled India to governed Bharat. So AZB and partners have started this article series analyzing the performance of the new criminal laws as well. I hope you check that out and you gain a lot from that. It certainly helped me a lot for coming up for questions for this panel discussion. So thank you, sir. And now moving on to Komal ma'am, we would like to hear your insights on the same question.
Thank you. Welcome all the galaxy of intellects here. I am an in-house person, so I would like to speak very little on it because we will be interacting more often. And I wish that the question should be asked to the external panelists more. But yes, here I would like to just make 2-3 remarks. Number one, sir, I believe that everyone will agree that the justice is hanging like a pendulum between justice delayed is justice denied and justice hurried is justice buried. So in दो के बीच में it is like a pendulum. The justice is just hanging like a pendulum. Yes, of course, the timelines are required, but yes, again, as far as the current scenario is concerned, the laws are prospective in nature. So what should we understand as a lawyer, as a judge? Do we have to stick to the timelines for the current, the upcoming cases, or for the previous ones? So if you are doing that to the current cases, and of course, due to the, as sir has already mentioned about the shortage of judges and the lots and crores of pendency of the cases, especially in the district court, still Supreme Court. So if we are we are giving fast dates and the fast appearings for the present or the upcoming, the current cases after 20, this amendment, new laws, what about the previous ones? Because it doesn't have the retrospective. So don't you think that it will be injustice to the previous cases? Because ultimately in those cases, you have to give the date for more than 6 months, 7 months or an year. So it will be injustice in those cases. Yes, of course, here I would like to just quote one thing. We were having the same discussion with one of the honorable High Court judge at Punjab at Haryana High Court. And we asked him, sir, do you find these 3 laws will change the whole scenario in the criminal justice machinery? He said, I mean, it is little discouraging, but he said that the criminal justice system of the country is irreparable. We have crossed that limit. So unless and until a major change is brought with multiple which we can say appointments of the judges, multiple establishments of the lower courts, we cannot solve with this current status here. So with this, I would like to request the moderator to please ask the question and let them have a fruitful discussion. The students are really enjoying that. Thank you.
Thank you. Thank you so much, ma'am, for your insights.
I want to say something.
Sure, sir.
If we want to get positive result of all those law, we are present here have to think over that we will be part of legal system and we will do our duty efficiently, whether as an advocate or as a judge or as a police officer, then the system will change. Determine. Yeah.
Investigating properly. I mean, they are delaying in the investigation charge sheet. They are not filing in time and they are seeking for extension for multiple reasons. We must understand we need the reforms in the police system also, which has been long desired for. The same police is used for the bureaucratic purposes. VIPs coming, the people are doing that, they are investigating, they have multiple jobs to do. And I think investigating for the case comes at the end. Most of the time it is.
I was selecting the universe for my ministry project, wherein I was to select the idea was to select the most matlab as in I was selecting it for alternate trial model. Okay, so what strategy I took was, okay, let me select the charge sheet rate. Let me take in consideration the charge sheet rate. Okay, so highest charge sheet rate in which state, lowest charge sheet rate in which state, and regarding IPC offenses, regarding special legislation. Okay. Now, when I looked the NCRB report, the highest charge sheet rate in IPC and BNS was Gujarat. Okay. And the lowest was Haryana and Delhi. So I selected these three states, though it was supposed to be four states, but because Gujarat qualified in both categories, so there were three states which qualified. Now, the first impression that this will give us that as if Gujarat police is very efficient. Why? Because the charge sheet rate, as pointed out in NCRB, is around 98%. 98 and 97%, wherein Haryana and Delhi, it is 26 and 27%. Okay. So now this is the first thing. But after the completion, because, you know, again, as an academician, as a person who is in research, you need to understand there are lies, there are absolute lies, and then there is data. Okay, now when at the end of my research, I came to know that what is the manner in which the charge sheet is filed. Lot many things are being done by Haryana and Delhi police. Otherwise, I'll discuss it some other time, which is not done. Maybe the charge sheet rate is higher because they are not taking anything on themselves. They are filing it mechanically without application of mind. See, if the charge sheet rate is high, doesn't mean that maybe they are under orders that, okay, you are not supposed to. If there is a complaint of POXO, file it. File the charge sheet. Don't get into the very idea, because more you pass the ball to the courts, more that is there. So maybe they don't this thing. Now, what is the finding? I'll not discuss here. But again, I'm giving just a very small example.
Yes. Thank you so much, ma'am. So my next question is to Dr. T.R. Naval. Sir, so basically one of the highlight changes of the new criminal laws is that they have incorporated technological advancements as well. So for example, in BNSS section 105, section 185, you have to, it's mandatory for a police officer to video record the search and seizure procedure from start till finish. Also under section 230, supply of e-documents to the accused and victims is supposed to fulfill the condition that the documents has been supplied to the accused and the victim. And also there is discretion of inquiries, trials and other proceedings that can happen in an electronic mode as well. So how do you think that they will help in furthering the cause of justice?
This is very welcome amendment and a new act. It is very welcome. I think that it will give positive result in future. But there are some limitations, because this is technological problem. The police officers at lower level, ASI, SI, or they have to perform their duties for recording of a statement at police station. There may be problem how to record the statement, what precautions are to be taken care of, so that the genuineness of this statement is not challenged. Sometimes it is very difficult to store the statements, because police has to record the statement in many cases, and they are not trained how to maintain those, where to keep those. Uh, there will be infrastructure problem for police, and technological problem, because recently training is required to the police officers, and trainings are given to GGs also. Training is given to police officers, and in due course that will give you a positive result to us, because when a confession or a statement is recorded by person, it is generally challenged that it was obtained under duress, or a statement was recorded by police officers himself, and later on his it is said that his signature was taken under compulsions, and sometimes even his signatures are not required under the law, but signatures are even then taken, and it is said that it made the confession, and in fact that confession was never made. It is challenged that I did not make this confessional statement, but with this result, when his statement will be recorded with the new system, audio, video, then it will give transparency. And it will be very difficult for the accused, even for the defense counsel, to say that it was not his genuine statement. So that may result into faster disposal of case. But care has to be taken for training part and infrastructure part.
I'm taking your role, and because I don't want to miss this opportunity asking this question to both of them. Okay, one more question which I am asking on behalf of you is that why lawyers are opposing or the move of getting the IO's statement by electronic means is being opposed. So what are the plus and minuses of an IO statement getting recorded from police station? So can I ask this question?
Recently, we have seen that there has been lawyers strike in all the courts of Delhi, on the point that it was notified by the LG that police officers need not to come to the court, and they will make a statement while sitting in the police station by video audio conferencing. So the plus point is that that lawyers should not oppose is that when the witness is formal witness. I hope that you understand the difference between formal and material witness. Formal witness is that when AFIR is recorded and it is brought before the court, FIR register, and is said that this FIR recorded. He need not to say anything more. He has to bring the FIR register and say that this FIR is recorded. This is called formal witness. That witness does not speak about the merit and or demerit of the case. And I say that these type of statement can be recorded by video conferencing while sitting in the police. There is no harm. But when material witness, for example, investigating officer, he has to come to the court so that the his cross-examination is conducted, so that the truth may come out whether he conducted the investigation fairly or properly, because it is not possible for the defense counsel to ask questions while he is at remote place, because he has to show some documents, he has to put some documents. It will create a problem while recording the statement. So so far as material witnesses are is concerned, has to come to the court. Besides, it is said that justice has not to only be done, but it should have been shown that it was actually done. So if a statement is recorded at police stations and judges pass order sitting at remote place, then the public will say that justice was not done, he was not heard. So this is the difficulty. And so my answer is that in respect of formal witness can be recorded at the audio, video, and in material witness, he has to come to the court.
Okay, so bunch of questions, but let's start with the first one what ma'am asked, and then I'll answer yours. With regards to technological advancements, and again, central statute, state issue, because there has to be earmarkment of funds. I'll give you an example in Delhi versus Uttar Pradesh. in Delhi, when you go to the courts now, there are e-filing processes. That means in the district court, you can go first file the soft copy, then file the hard copy, so there are both records contained. Delhi High Court, on the other hand, is completely paperless. Now you can do a completely paperless filing from your house, even at any point of time, late at 1 o'clock or morning 5 o'clock. I have all of my files in my iPad, by the way, so we don't use physical files if not required. Now, compare this scenario with Uttar Pradesh, which does not have earmarking of funds. There is no computers in the district courts, so the judges who are also allow for VC either do it by handsets or they do it or they don't do it at all. In Delhi, even the district courts have proper WebEx links. That means if you are a person, and again, why this is important, let's say you are a person out of Tamil Nadu who came to Delhi and got involved in a particular event. You have now taken bail, you have gone back to your place, but the trial still continues. Now you can take permission from the judge that I will join by VC. That means for every date, you don't have to fly down from Tamil Nadu a day before, come to the court. You can do so by VC if the permission is granted, if that's the bill condition. But the ease of people joining and listening to their matter has changed. Courts have also now asked for live streaming of these cases with the intention that there is transparency. Because what we often hear is media trials, that this did not happen, this happened. But once it's online, it is only for the purpose of transparency that they're willing to show you that this is how the situation works. Again, first year, second year law students may not get the finer points on this, but imagine the reason that I stepped down and hit somebody. You will obviously want due process of law to be followed. That how could I have done that? Now imagine you are wronged in some manner and you don't get a way of following the litigation or following the criminal implication. You will always be unsatisfied that this event happened, but I did not get justice. That is why transparency and the technology bits help. In Uttar Pradesh, you go to the High Court. So let's say you get a dismissal here or you have to file a quashing petition. You go to the Allahabad High Court. In Delhi High Court, if you file a petition prior to 12 p.m., which is defect free, it gets listed the next day. In Uttar Pradesh or Allahabad High Court, when you go for a quashing petition, it doesn't get listed for 6 weeks. After 6 weeks, you'll have to mention the matter to come on the board, and then only notice gets issued because they don't hear because they have a large pendency. So pendency also gets affected because Uttar Pradesh is the biggest court, and there are a lot of events which contribute to it. So technology is definitely working. States have been asked, high courts have been asked to be centrally containing documents. Another sample is when you go to appellate forums. Now the Delhi High Court can all call for the trial court record in a completely digitized form, attach it to their file so they have access. Otherwise, this process of getting the documents from the trial court to the High Court usually takes 6 months. So the benefits come in. Another example is status report. Once the police files a status report, you go to the court. It is there in the morning at 10 o'clock in the judge's computer. You insert a pen drive or you take a PDF copy. You have access to the PDF report. Otherwise, when the filing used to happen one day, one date would have gone, and the next day you will fight, and by that time there'll be a difference in the status report. So smaller technological events are changing things. If it's starting slower, it is at least coming there. You did not imagine that the COVID pandemic would have changed lives, but VC hearings have now come in India. And by far, if you compare from strategic from timelines from Australia and US, Australia and US judges visited Delhi to see how the system was working, how flawless, because they have filing protocols which are e-filing, but they don't have a software which allows you to do it from your own home. They only have logins to access the computer and how to file it there. And the filing itself, the process is now being used by large masses. So that is one benefit. Now coming to ma'am's question with regards to the notification which came from the LG. Now imagine a scenario that I'm in front of a computer. You only see this side of my area. The three elements which came in with the notification, one got revised and then the notification went away altogether. Now imagine there is a person who's committed a crime. He's in jail. He's a pending under trial. So he's currently only a accused person. He's neither been convicted. He's neither been not convicted. So currently he has to follow, or there is a presumption that he's innocent until he's proven guilty. Now imagine a scenario that he's being brought on the VC and the apprehension, and which is what the lawyers were doing so. If they imagine a person standing in front of the VC with a gun pointed at you, saying you say this, otherwise I will shoot you. Unlikely it may happen. But the possibility, can it happen? Yes. Similarly for an IO who is supposed to give statement, I understand the statement that sir meant, being a formal witness versus a material witness, which is very important. Because a formal witness is just supposed to, there has to be a person who is just giving a confirmation of filing something. But as a defense lawyer, every small procedural matter matters. every procedural flaw is your client coming out of jail to not conviction to being completely scot free. That is why it is the job of the person who is representing which side. Now, as a defense lawyer, you will say the police made a statement and the statement was audio video recorded. Now, they will say there is AI, there is complete modulation, this is not what he wrote, this is not the statement he signed, because there is a presumption that any statement written in front of the police or convention or a confession is not admissible into evidence. Now, if somebody is basing that to be the sole basis that see he wrote and there is a video proving that he wasn't there, nobody was pointing a gun at him, it is completely scot free, that statement should be used and he should be convicted. Now, that completely botches up the trial to a larger extent. So, these notifications were basically advocates' way of saying, and pro con either ways, to say that we are trying to safeguard your freedom, your procedural nuances. Advent of technology can only happen when there is adoption in the most bona fide manner. But when there is a possibility, a mere possibility that something can be impacted, that your freedom can be at stake even for a microsecond, then that should be done, because the Latin maxim goes that 100 go scot free, but one innocent be made into or thrown into the criminal justice system. That is what we have to think about. When we do larger scales of, say, white collar crimes, you can also look at it from a corporate structure where this is just a corporate raid. So for a company, it really doesn't matter. But for individuals, or even individuals who are managing those companies, when they are coming into this situation, you will try everything to ensure that there is complete justice. You cannot have a situation that a person makes a statement, or the police is supposed to come for cross examination and the guy is on a VC, and then he says, "Sir, sorry, I did not hear the question." Sir, kya? Because now he's thinking about the time to answer that question. If I ask you a question and you are in front of me, you can answer instantly. If you don't answer, I'll tell the judge to compel him to make you answer. But if you are on a VC, there is coaching happened. There is somebody writing on a piece of paper, somebody showing placards. He can be coached. And coaching or the trial factor, both in civil and criminal, is the only factor which is supposed to be done in the most effective manner, because that will make or break your case. Because pleadings can be throughout, pleadings can be anything. But once the person who's coming to defend those pleadings is supposed to be crossed, he will tell you what was the reason. And here the finer points do come into play. Like the charge sheet timelines. If somebody files a document which is semi, it's not complete, and he takes permission, and he only files a document to complete, then the argument will be there is no investigation, there is no new material. This was always part of the charge sheet. Why didn't you file it then? This is now you bettering your case. Supplementary charge sheet can only come in when there are new evidences which have come out as a consequence of further investigation. But if I'm saying that I had seized this phone and the phone was seized and the phone was not analyzed, you can take a limited permission that is gone for forensics. Let the forensic report come. I will put that forensics on record. But if you say, yeah, the phone was taken, I had sent it to forensics, yeah, but I forgot to take permission or forgot to mention the IMEI number. Now, how do I know whether the phone was tampered or not tampered? How do you know that this is my phone? I have not seen the analysis. I will now ask for the documents. I will ask for the clone copy of the thing. I will ask, where did you find this document? And this is what happens. In larger crimes where they will take hard disk upon hard disk, the prosecuting agency will now cipher through that documentation. They will have to, under the new BSA, specify where a file was found, where the pathway is given, what is the hash value, and give a 63 certificate. If a certificate is not given, it is not admissible. So it could be the biggest of smoking gun, that there is a document which shows that this was being supposed to be done in a particular manner. But if there is no 63 BSA certificate, it will not be admissible. And these parameters differ from case to case. State jacket formulas cannot be applied, differs from civil to criminal. That is why these implications matter. And again, ma'am, just to confirm that point, lawyers did it without, let's say, without an agenda, because the larger scheme of things would have been to ensure that if a person is arrested, I have the access to the victim, I have the access to the police officer, because if he tries to botches up in some manner, or he doesn't answer, or he shuts down the computer, there is very limited the judge can do. And once you know the stand or the way the cross is moving, you can anticipate, and that anticipation cannot be let go. It can only be with the permission of the court, and only the court should have that prerogative of how that witness is supposed to be treated, let go or not, because the compulsion or compelling him to answer also comes from him. Technology cannot be a substitute for speedier justice if it is at the cost of the victim.
And you know what? the input of the police officers was, and the basic understanding of this was that even the conviction is not based on the statement of police officer, the IO, but the acquittal can be. So the saying that there is a very thin line between, see, academically there's a difference between formal witness and material witness. But what is material for a defense lawyer, what he was pointing out, that for me an IO and his statement is very important for getting my client out of the clutches of criminal justice system. So why I should? So that is why what I was saying was that there are different ways. What side of the what side you are arguing, that is how you will understand the changes. And you know what, one more thing, you have changed procedure, agreed. Now there is no this thing, I'm not criticizing, but you know what, speedier, but when you see BSA, the evidentiary value of whatever is said in the police custody, howsoever it might be recorded, or it's a primary evidence, no doubt about it. But then, have you changed the principles of admissibility of evidences in the court? No. The answer is no. So how things will change? So please understand, calling people, calling forensics expert on this thing, that police was doing earlier also. It was not that the police was not doing it earlier. They were called. But now they are compelled. See, anything what is written. There was a very good example that one of the spokesperson gave somewhere, that RTI, right to information. Things changed when RTI came in black and white. Okay, Lalita Kumari was there. Priyanka Srivastava was there. These are very leading judgments you will be studying. But now they are part of BNSS. So maybe things will change when they are written in the law black and white. So we cannot undermine the changes, the importance of undermine the changes. But how far they will change, how early they will change, again, it's a matter of debate.
Thank you so much, ma'am. So now my next question is to you only. So since the BNSS also talks about victim compensation under section 396, and the question with regards to that is, it's more inclined towards the legal aid aspect of it. And why I'm asking you this question is because you had done a study on unraveling the factors of acceptance of violence in marriage by women. So basically, we have heard about the concept of victim shaming, but what to do when the victims are shaming themselves and they are justifying that the violence that is happening to them in the marriage is in some way justified to them, and they're not coming up, and the legal aid is not, they are not getting the appropriate legal aid.
You are talking this thing, whereas the public debate is that women are misusing this. They are overusing it. Okay, number one. Number two, see, please understand the typology of every wrong is different. Whatever wrong is done in private spaces, among intimate relationships, they cannot be understood like this. You will require another session, complete session for this. Okay. Now, as far as the victim, I'll quickly talk about this. See, victim-centric approaches, yes. Keeping victim informed about the proceeding, about the investigation, about the charge sheet, even listening him at the stage of withdrawal. Agreed. These are very, very welcome changes, amazing changes. But you know what? Things work on a very different pedestal when we see in reality. You know, the highest number of hostile cases, hostile witnesses in case of dowry death. Can you guess who is? Can anyone tell me in dowry death trial? This I'm talking about generally, okay, not specifically maybe. The chances of witnesses getting hostile are higher of which side in dowry death? Anyone? Any guesses? Who gets hostile very quickly in a trial in dowry death? Dowry death है, women तो मर गई. See, imagine, they are absolutely correct. Now, when does it happen more? Any guesses? When there is a child involved. when there is child who is left behind, the chances increases. I'm not saying 100% it would be. No, that is not the case. See, please understand the concept of victim, the concept of victim, what is a just way of dealing with victim. For instance, I'll tell you one other example. There was a very beautiful study conducted in NLU Delhi, wherein they interviewed, it was a case study method, wherein they interviewed the POXO survivors, okay? It was on rape. The idea of justice in case of POXO, in where there is a child sexual abuse, okay? There was one case study that I read and I was shocked, and then what to say? I again revisited my idea of what is wrong, what is right. You know what? She was a girl of 13, 14-year-old, she was, and her father was molesting her. She filed a complaint. Okay, now he was in the jail. Now, when she was interviewed, when the case study that she narrated, she said that I didn't wanted this. Why I didn't wanted this? Because my father was the sole earner of the family. Had I known that he would be in this thing, you know, my sibling, my all studies were stopped. Now we are on roads. There is nobody taking care of the education of my younger one. I wouldn't have complained if my father would have kept only me molesting and not my younger sister. I complained when he shifted from me to the younger one. But then again, you know, her idea of justice was very blurred, was very blurred. That what is the right action? What is that? Because see, the court did the right thing, sent him behind the bars. In POXO, you'll not even get a bail early, very early. Okay, so now the thing is that what she's saying, I know academically, morally, that is not the correct thing. How we understand the compensation or justice? No, that we don't understand. But is she completely wrong? But can it be said that whatever she's saying, out of innocence, she's saying, out of this, she's saying that now there is nobody to take care of our family. We are all working in our houses. We can't go to school. So again, victim-centric approach, yes, there are new changes there being involved, but you know, making law is the easiest thing that the state can do. That is what my tagline is. That is the easiest thing, increasing punishment, increasing the number of criminal laws. You know, there was a very beautiful article in Indian Express. There are thousands of ways to get in jail in India. How many thousands of jail? You read it, you'll find it on Indian Express. I'm having a copy of it. That how easy it is to put someone behind the bar. And believe me, no one is bothered about conviction or acquittal. You make process the punishment. The approach is make process the punishment. Okay.
Thank you so much, ma'am. And sure, ma'am, I was coming to sir only after this. And thank you for putting that point that you make process the punishment, and that is the real punishment for any under trial. Yes, ma'am.
In bailable offense, you take 7 days to realize that the person is indigent. Long back, 2005 we made that changes. Where this 7 days? 7 days. That means if the person is not money, he should be behind the bar with 7 days. And bail again is a very different. My student said mandatory bail 436 capital A. Half of the punishment he becomes first entitled. Then if the prosecutor disagrees, then for the maximum punishment, okay, he can be kept in the jail. He becomes mandatorily entitled in 436 capital A CRPC once he is behind the bars for the punishment that can be maximum given for the offense. Okay. Now suppose he is tried by first class magistrate. He can only be given 3 years, but he is trying an offense which is punishable for 7 years. That means bail is to be given mandatorily after 7 years of the offense that the magistrate can only pass sentence up to 3 years. What is it that we have achieved in 436?
When such a question arises, then that judicial magistrate has to refer the case to chief judicial magistrate who has power to sentence up to 7 years. So this is the answer to that question. When I was coming to this institute, I saw a notice board, legal aid clinic. I am very happy to know that legal aid clinic is being run here, and you are doing a wonderful job for help of the victims or the accused persons who are involved wrongly or for so many other reasons. So previously there was legal aid only for accused persons, and there was demand that legal aid should be also for the victims. Now, under the new law, legal aid is also provided to the victims, and there are special provisions that not only legal aid but compensation has to be provided to the victims, even in those cases where offender is unknown or he is not found out. Even then, the compensation can be given to the victim. And there are other previously during bail applications, the victim was having right to participate to oppose the bail application, but now victim can participate in the entire case. He can or he or she can engage his private counsel to assist the public prosecutor regarding conduct of case, or address the arguments, or even uh, amendment was earlier passed that victim can also file appeal if case result in into acquittal. So there are several provisions in favor of the victims now, and the law has become victim centric, and there are so many other provisions. When suppose the victim is acid attack victims, then there are provisions in, that that victim should be given a regular job in the government. So in Delhi, legal aid committee has given job to several victims, and they are doing wonderful job. So uh, the new law will provide and is beneficial for the victims also.
Thank you, sir. So, ma'am, can we have one final question for the panel? Uh, I have a question for you, but if you can.
See, victim compensation, I'll just give you a very small example. And can I say no shots left unfired? Every technical or a heavy stake question which was not supposed to be asked has been asked. But let me give you an example. This is a case day before in the Supreme Court where somebody has filed a case that a person who was in jail has undergone his complete sentence, but he wasn't let go. It was a case before Justice Padewala where a person said that I am filing a case because I don't know why I'm in jail for. To my best of my knowledge, my sentence has run out. The state comes with an answer that we weren't directed to release him. He said who was supposed to be directed. Then they found out that the directions from the jail superintendent did not go to the state for confirming that the person is done and his jail is there. Do you care to give a guess how long he was in jail after serving his sentence? Any wild guess? 5 years. Because under trials and don't have that money. In law, when you are rich, you can have people fighting a matter, a bail is dismissed, go to sessions, go to supreme, go to the high court, go to supreme court after every bail, and you try to figure out. So that's why when they say that if you are rich you can get a bail faster, is not entirely incorrect, because once you're an indigent person you don't know your rights. And because sometimes the lawyers who are working are also so pressed with time that they do not give all options. Normally everybody can go to the Supreme Court, it'll take time, but the point that when should one go, when should one apply for a challenge, those are strategic inputs which people have to understand from lawyers. That's why your job is very important. Once you want to come into this profession, your job is equivalently important to the bar and the bench. You have to represent your client to the fullest of extent, but you also have to treat him with the same respect that you would that if it's somebody you knew. Because once you are going before the bench, you have to figure out and look at the nuances that they also go through. A judge who is dealing with 200 matters can only look at the matter for the purpose it's before him. He doesn't look at the other parameters. If you're filing for bail, he's not looking what the offense initially was, how it has been investigated. He's only looking at that bail, and he will look at the principles of bail while determining those factors. So once you have other nuances, you have practical challenges, you have defenses. If you are doing so, you also highlighted it. That's why every part and facet of the process is important, and your understanding of this process is furthermore important. Ma'am, we should go to the next question now.
Thank you so much, sir. There is just one of the very controversial uh, uh, sections that have been inserted into the BNSS, which is with regards to the police custody, section 187. Since we also have a paucity of time right now, I would just like to have your quick views on the same. That earlier, section 167 CRPC, it gave for 15 days of police custody followed by judicial custody. The timeline is still the same, maximum 15 days. However, now they can be given in part for the first 40 or 60 days of the judicial custody. Now it has wide-ranging repercussions on bail also, and as ma'am was saying, that make the process so difficult and uncertain for the accused that he is just cornered into making a choice that he would not have made otherwise. So just to have your final opinion on the same, sir.
What Bam said, that the process is the problem, it's not entirely wrong. When you do these matters, and as soon as you get into legal trouble with the law, oh, it's a nightmare to begin with, because the same principle is being challenged into multiple cases currently, because there are also problems as to when these periods start. If I put somebody without a FIR coming into play, but I restrain him, this period is not considered. So you're also looking at how the 15 days begin. Can the 15 days stop in the middle? Can I take him out on bail and then take him again? Or do I charge him now, charge him later? There are various practical nuances to this issue, and this is the same is being challenged before the Supreme Court as well. When you look into white collar crimes or any kind of criminal cases, we have various stages, we have various levels of complicity. If a simple recovery case is supposed to be looked at, or somebody snatches your phone, that goes on for years. Imagine when you're dealing with a higher embargo where somebody, I'll give you an example. The ED cases which have now started coming in, I am doing a matter before the FEMA Appellate Tribunal where a person who was a CMD of a particular bank, so the largest bank in that case, he had taken a transaction with his sister concern, which is another bank. And that sister concern had taken compliances of other two sister concern banks, because it was a joint venture model for multiple jurisdictions. They got looped into a FEMA violation, which is a problem between the company, not the bank, because the money has not flown from India, it's gone from the abroad side, because the bank also had an Indian branch. They have looped in everybody. What is the violation? We don't know. The adjudicating authority did not see the documents which are now being shown in appellate, saying that these documents were never before we saw. I said, how did you come to that finding? So nowadays, what happens? The prosecuting agencies are trying to fight even on bail, which is why the problem has started to emerge that they don't want anybody to get bail. Bail is the right. And only exception is when there is a criteria that the person can abscond, but because of the serious nature of offenses, everybody said there's 8,000 crores loss, there's 15,000 crores loss, the exchequer is losing. It wasn't losing money when you were investigating that entire crime. The banks were approving this. So it is a larger gambit of reasons. And such a case where the bank is not at fault because the Indian bank did not do anything. The only thing he said, I will connect you to my foreign counterpart to another bank. Who is the one given the money to an outside bank? They are saying that is now a challenge under FEMA law in India, while there is no transaction in India. And that person has been now suffering this trial since 2018. He's at the verge of retirement, and he's not getting a job because he's been suspended on the ground of this particular case. The ED is not investigating or completing investigation because now 18 other people have been taken as co-accused who are not being represented. I am the only one where pleadings have been completed. I file an early hearing every time, but the matter doesn't come in because ED resists that the other matters that other co-accused are pending. Because in law they cannot separate trials. Because you cannot separate trials, you have to continue together, and they are not completing pleading in that. 3 years have gone by, they are not filing a response. And that is the nuance that we're fighting. A person who's actually losing his job because he's at the verge of retirement. Why? Because there is only a supposed case against him. No conviction. There is no conclusiveness and there is no document on record. But now in appellate, they have introduced 2,500 pages to show their emails. Not one of the emails have been so far looked at from a perspective of evidentiary value. So this is the problem we have.
Thank you so much, sir. So now we open the open the stage to the audience members if they have any question from our esteemed panelists. We can accommodate only one or two questions at this point. So if anyone is interested, can raise your hands. Yes, please.
Welcome, sir. I'm S. Shekhar from BBLV second year. Sir, my question is about for legal aid. How are the new criminal laws are better for the legal aid to underprivileged or poor people for the in comparison of the old criminal laws? Thanks.
Legal aid is generally granted. There is a law, Legal Services Authority Act, that prescribes how legal aid committees at central level, state level, and district level, taluka level are empowered to give legal aid to the victims. So, under the new law, as I said earlier, the concept of legal aid was broadened, and practically, if you will see, there are I will particularly talk about Delhi. In Delhi, there is a Supreme Court Legal Aid Committee in Delhi High Court Legal Services Committee, and in each of the district there is district legal aid committee headed over by district and session judge, and managed by a judicial officer who is secretary there, and there are taluka level committee, and the legal aid is not given to the accused only, it is given to the victim. If the victim says that he or he is unable to file his or her case, then legal aid is also given to her or him. So, and for that purpose, lawyers are selected for at each level, at Supreme Court level, at Delhi High Court level, at district level, and at taluka level. A panel of advocates are selected and given job. Apparent officers are being run, and materials regarding law trainings are given. What are their rights and duties? Training are given, lectures are given, public are made aware. So many programs are organized and held by the district level committee, high court level committee, or in fact, legal aid is now doing a wonderful job. It was not earlier. So the new law is giving good facilities to the victim and as well as to the accused.
Thank you so much, sir.
I'll just add one thing. Effectively, there is no change in terms of the law for legal aid. They are just benefit actions, because I forgot to complete that part of the story. When in the Supreme Court, where the person who was incarcerated for no reasons, the Supreme Court has granted, in terms of the BNS, a compensation of 25 lakhs. So that compensation factor has increased, and therefore legal aid lawyers can also file other proceedings for ensuring that the compliance, and legal aid is done only for committees where you cannot handle or get a lawyer for your own case. So you're not condemned and hurt. You have just been assigned a lawyer.
Thank you so much, sir. Thank you, all the dear esteemed panelists, Dr. Abhimanyu, Dr. T.R. Naval, Dr. Upma Gautam ma'am, and Professor Dr. Komal Veg ma'am also, for your varied views, diverse views, and all your opinions on the same. I want you to applaud them for their opinions and for giving us time. So just quickly concluding today's discussion, we had discussions on the topics of timelines and whether rigid or stricter timelines would be helpful in speedy justice. Secondly, we also discussed about the police custody and whether the new section 187 is going to be a hindrance to the accused and the rights of the accused. And lastly, we also discussed the introduction of audio video recordings in search and seizure procedure, which has been mandated in the new BENSS. So with this, I wholeheartedly thank being here. Now I call Susanna on the stage for concluding the proceedings.
Thank you so much, ma'am. I now request our officiating director, Professor Dr. Komal Vig, ma'am, to felicitate Dr. Tia Naval, sir, with a token of our appreciation. I now request Professor Dr. Rajendra Kaur Randhawa, ma'am, HOD DME Law School, to felicitate Professor Dr. Upma Gautam, ma'am, with a token of our appreciation. I now request Mr. Anand Singhal, sir, faculty in charge, DME Legal Aid Cell, to felicitate Dr. Abhimanyu Chopra, sir, with a token of our appreciation. To express our collective gratitude to all those who made this day possible, I now invite Professor Dr. Neha Behel, ma'am, faculty convener, DME Legal Aid Cell, DME Law School, to deliver the vote of thanks.
Okay, so I would thank everyone, the panelists. We had a intense discussion. Thank you, Komal ma'am. Thank you, Naval sir. Thank you, Upma ma'am. And thank you, Abhimanyu sir, for gracing the occasion and enlightening the students and participants. Thank you, faculties. Thank you, HOD ma'am. Thank you, Anand sir, for your support. And students, participants, see you next time. Thank you so much in the panel discussion too. Okay, thank you.
Thank you, ma'am. Thank you, everyone. And we are very grateful to each and every member of the audience for being a part of this event and making it a great success. And I request participants to please be seated.
everyone is please requested to please